Hi everyone, welcome to CL-LST. So from last many classes we have been discussing contract and this is the last class of contract. So we are done with contracts, few topics I'll be taking over here and then we are done with contracts. Then maybe we'll pick up another subjects. So when we say the basics of contract where we have taken into consideration, the very basic of like offer acceptance agreement, then we have also discussed as to when the contract becomes void, when the contract becomes voidable. We have discussed competency of parties, we have discussed section 10 in detail, all each and every five ingredients of section 10 in detail. So now we are moving ahead with contingency contract. So what is contingency contract? Something which is based on condition, something which is based on happening of something or performance of something, or you can say something which is dependent on a future event. For example, if I say if it will rain tomorrow, then I'll go to place called XYZ. So the going of me to place XYZ is dependent on the rain thing. So definition of contingency contract says a contract to do or not to do something if some event which is collateral to such contract does or does not happen. So if it will not rain, I'll not go. If it will rain, I'll go. So here rain has nothing to do with the my going and me doing whatever contract I am going to sign or me working over there. It is just something which is collateral to such contract. That means the performance of contract is based on raining. So when we say essential element of contingency contract, so obviously it's a contract. The definition of contract says an agreement which is enforceable by law. So contingency contract is something which is enforceable by law. So it is a valid contract. The performance of contract must be conditional or dependent on the future event. So here there's a future event. The future event, let's say in my example, is raining. So that is why it is again a kind of contingency contract. There must be an uncertain future event. That means I cannot control if it will rain tomorrow or if it will not rain tomorrow. There's some sort of uncertainty in it. So that must be there in case we are taking into consideration contingent contract. It also says contingent contract based on an impossible event is void. So if I say that if sun will rise in west, then I'll go somewhere or I'll sign the contract. So this is something which is not going to happen because sun is never going to rise in west. So this is something which is a kind of impossible event. Or for that matter, if I say if there will be a volcanic eruption in Delhi, then I'll take the classes. So again, this is very impossible because we don't lie in the volcanic eruption zone. So all these are example of contingency contract. Here, the example is also saying A contracts to pay B rupees 10,000 if B's house is burned. This is contingency contract because the payment of 10,000 is dependent on the burning of somebody's house. And if the house will get burned, then only the other person is going to pay him 10,000 rupees. So, this is another perfect example of contingency contract. If we have to understand from daily perspective, our day to day perspective, so you all know about the insurance, which is also known as contract of indemnity. It is an example of contingency contract because when you take a car insurance or when you take a health insurance, so when it is being performed, if your car will meet with any accident, then only insurance company will come and make the payment or will take care of the accident. Or if let's say you have taken health insurance, so the insurance company will only pay you if you have taken some services of the hospital, you have spent something out of your pocket. So there the insurance company is coming. Otherwise, if you are a very healthy person, no health issues, then in that case they are not going to come and take care of or pay the insurance for your daily ka food or daily ka living style. No, the contract is if there will be any health issue in future, then I'll be taking care of it. So that is what is also known as contract of indemnity. So this is about contingency contract. Then when we move ahead, we have contract of wager or agreement of wager. Wager cannot be a contract. Why? Which because it is something which is void. This is something which is illegal. This is something which is not permissible by your state. And that is why it is known as wagering agreement and not wagering contract. So wager is where you are putting a bet on something. A contract by which two or more parties agree that a certain sum of money or other thing shall be paid or delivered to one of them, on the happening or not happening of an uncertain event. Here also there is an uncertain event, you know, part of it. But here the idea of party is that you are entering into a betting or a gambling sort of thing, and here you don't have any other interest other than just winning or losing. For example, if you put up a bet on any match, so your idea is only to win or to lose. You don't have any control on the event, you don't have any control on the how the player is going to play. You just want that if X team wins, you win. If Y team wins, your opposition wins. So that is what is wagering agreement. And agreement by way of wager avoid agreement. And no suit shall be brought for recovering anything unless to be borne on any wager or entrusted to any person to abide by result of any game or any uncertain event on which the wager is dependent. Essentials of wagering agreement is it is uncertain event. There's an equal chance of winning or losing. So if you're putting up a bet on the match, so either you will win or your friend will win. So you both are having equal chance of winning and losing unless or until the match goes for draw. Neither party have the control of the event. You don't have a control on the how the players are going to play, who is going to play the match first because toss hoga. So you don't have any control. The only thing is you are there just because you want to win. No other interest in the event except the money lost or won or lost. Betting and gambling is the example. Horse riding in India is not illegal. So if the prize money is less than 500, then it is kind of is being taken into consideration. There are certain exceptions to wagering. The exception is if something is based on your skill, something is based on your knowledge, where you are putting or using certain skills of yours. You are applying your brain. You are like, let's say, if you are playing something on Dream 11. Dream 11 is being run in India. It is not following another category of wagering. Although it is on a game, there are chances of winning or losing also. But there's one catchword over here, that is your skill. You are picking players from both the teams basing on their performance in the last match. You analyze the performance of player and then you choose them. So in that case, your skill is coming into picture. So it will not fall within the definition of wagering agreement. Similarly, if we take into consideration Sudoku or a similar crossword, where your skill, your brain, your application, you are applying your critical or analytical reasoning over there. So, in that particular case, something like that will not fall within the definition of wagering. But otherwise, contingency contract is a valid contract. Wagering agreement is a void agreement because it is based on betting or gambling, which may be, uh, which may have been declared illegal by the state, and in that case, it becomes a void agreement. Then the next is contract of agency. We know the concept called vicarious liability under law of torts. Agency is also part of vicarious liability, you can say, but here what we are reading is from contractual perspective. That what is a contract of agency? So if A is doing something on behalf of B, where B has given all his work to A, then here A is working as an agent of B. And whatever A will be doing under law, it will be presumed that B has done the work because B has assigned his task to A. So that is what is contract of agency, that a person is appointed to do any act for another or to represent another in dealing with third person is an agent. The person represented is called the principal. So the here B is being represented by A. B is called as a principal, A is called as an agent. Contract entered through an agency, an obligation arising from any act by an agent may be enforced in the same manner and will have the same legal consequences if the contract has been entered into and the acts has been done by principal in himself. So the idea is if you are hiring somebody to do something on your behalf, so that person is not doing his own work, the person is doing your work. Whatever instructions you have given, the person is following it, or maybe the person is representing you. So in that case, if anything, like if he whatever he does, it will be under law presumed that it was done by the principal because he is representing principal. His own interest is nowhere involved, he's just doing his job. That is what is contract of agency. Again, we have discussed under the general definition that the contract offer can be a general offer, offer can be a specific offer. General offer if it is being made to public at large, specific offer if it is being made to a specific person. Similarly, agency can be general agency, agency can be specific agency where a person has been appointed as a general agent. That means he is taking care of all the works on behalf of Mr. B. Then, in that particular case, it's a general, agency. And specific is if a person has been just hired to sell his car. So in that case, he cannot go and sell his house because he was only appointed for selling of car. So here, specific purpose is attached. So this is known as specific agency. So A appoint B as his general agent. B enters into a contract for sale of A's car. A is bound by this contract. A appoints B as his agent to sell his crop. B enters into a contract for sale of A's house. Again, crop के लिए था आप घर नहीं बेच सकते हो. So he went beyond what has been assigned to him. When we talk about how the agency is being or agent is being appointed, so we have discussed under the basic definition again as to how the contract is being made or how the offer is being made. So we have seen that offer can be expressed one, offer can be implied one, it can be quasi contract also. Similarly, agency can be expressed one, it can be implied one, or it can arise even out of necessity. So express is where A is clearly saying that from today onwards B is my agent. So he is expressing, he is telling everybody. So there's an expression sort of thing. So here this is known as express agency. Example is saying A appoints B to represent himself. A may appoint B as a general agent or A may appoint B for a specific purpose. But there is a express appointment which is happening over here. Then second is necessity. Even if a person has not been hired as an agent, but because the situation is like that the other person is not having any other option rather than taking the call on his own, so that the person on whose behalf he is working does not suffer from any loss. So, for example, here says A was B's employee. B asked A to take a huge consignment of fruits and go to Chennai. A got stuck at Lucknow without any means of transportation or communication. So here he is dealing with a perishable item, which is fruit, and he is stuck. He is supposed to go to Chennai. He is stuck at Lucknow. There is no transportation, no communication mean available. So in that particular case, if he does not take a call on his own, the entire perishable item will get ruined, and the person A will suffer loss. So here, if B takes a call on his own, because the situation is like that he has to take a call, so he ends up selling the fruits at Lucknow. Then we can say that here the contract has, the agency has been created through the requirement or through necessity. And the last one is conduct of the parties, which is implied agency or estoppel, where again we have discussed how implied offer is being made. You're not expressing your desire, but through your conduct, through your gesture, it is very much reflected. So here again the example says the same. A went to a party. X said to Y in A's presence that he was A's agent. A did not refute this. Y may presume that X is his agent because he is neither saying yes nor saying no. So जो भी वहाँ पे लोग होंगे, they'll assume that he is working as an agent of the other person. So this is the conduct of the parties. Similarly, the second illustration says P, Q, R, and S were partners in a firm. In P's presence, X represented to A that he was an agent in P's firm. Again, P did not refute it. A may presume that X is the agent in the firm. So unless and until you say no, how is the other person going to believe it? So either you make an express one. If you're not making the express one, your conduct, your gesture will reflect that there is a other party will assume that this person is working on his behalf. So there, the contract of agency gets appointed. Then the last one is contract of bailment. Bailment is, if you have to understand in a layman terminology, you have given something for some specific purpose, and once that purpose is fulfilled, you get your goods back. That, for example, if you give your clothes for dry cleaning, So you are giving your clothes for a cleaning for a specific purpose, that is to dry clean your clothes. Once it is being done, the dry cleaner is supposed to return your clothes, right? So that is what is bailment. A bailment is delivery of goods by one person to another for some particular purpose. When such purpose is accomplished, the goods are to be returned or disposed of as per the direction of the person delivering them. Not a perfect example of bailment, but to make you understand, a very simple example which we do on our daily basis or regular basis is we borrow books from library. So we get the book for a specific days, maybe 3 days or 4 days. Once that time period is over, we are supposed to return it back. So this is how the contract of bailment works. That if you have got something, if the time period is over, you are supposed to return it back. Example, A owns a DVD shop. B comes and take a DVD on for rent. A is the bailer. A has given the DVD, so he's the bailer. B is the one who took the DVD, so he is the bailee. And once the time period for rent is over, B is supposed to return back the DVD. Similarly, A puts his jewelry and other valuable in bank locker. Is this bailment? Yes. This is also bailment because you are giving the goods or you are putting up your jewelry in the bank locker for a specific purpose. That specific purpose is that you want it to be safe. And whenever you want to have it back, you can have it back. That is what is contract of bailment. The bailee is supposed to take as much care of the goods as would a reasonable, prudent man take of his own good. So if you get a goods from, if you, let's say, again, going back to our library wala example, if we borrow a book from library, we have to keep it in perfect shape or perfect condition. अगर हम कुछ भी गड़बड़ करते हैं, we are supposed to pay the fine. Or maybe if the book is being lost, then we are also supposed to return or purchase a new book. Similarly, if you put your jewelry in the bank locker, if was with you, you would have kept it very safely. So you would want the bank also to keep it safely. So the bailee is supposed to take as much care of the good as would a reasonable, prudent man take of his own good. So this is all about contract, guys. We have been doing contract from a very long time, but we have covered each and every topics of contract. Maybe in from next class onwards, we would be starting ahead with either torts or will be starting ahead with constitution. So this is all about today's session, guys. See you guys in the next class. Thank you.